Brian Parker again coming at you. I'll say it right away, snooze alert. This one may be a tough one. This is about hearsay. You hear on TV and you hear everywhere around the law. It's probably the most popular statement around the law. So we're going to look at what hearsay is and how debt collectors avoid it to get their stuff in, and how they have the assistance of judges that kind of look the other way. No judges in particular do this. It's just my perception when I'm in the battle with these hearsay exceptions. So you got to remember this is going to be kind of snoozy. So before you fall asleep, like, love, and subscribe. Leave your comments. Boring Parker is I'll give you a word template on that if you want. And 2, what's with the glasses? I got to read this stuff today. My eyes are bothering me, so I got to cast vanity aside. So last video, my salliemae video, there you go, there it is, and that was about dealing a blow to salliemae using their own documents against them. So the debt buyer uses these weird just conglomerations of many documents. In this case, as you'll see, it was just many signatures forced onto one page. It clearly is not the same document, and I'll show you what that means to you. The biggest hurdle for debt collectors to overcome, although lately judges are kind of, as I said, being more flexible, is the hearsay rule. How do you get something in? So let's take a look at hearsay. Again, snooze alert. All right? So I'll put it up, and I'm going to keep saying it. Why? Because that's how I learned it in law school. I'm going to give you what the evidence professor said to us day one. So there you go, Shazam. And hearsay is an out-of-court statement offered to prove the matter asserted. So you're in a situation and Steve told you that Bob did it. So you, Dave, are sitting there going, Steve told me. Well, that's an out-of-court statement. Steve is not here to testify today. Offered to prove the matter asserted. Bob did it, if I got that right. And Dave is saying this. So another way that we were given in law school, as I just mentioned, the evidence professor said to us, here is a perfect example of hearsay. He said that she said that he has halitosis, bad breath. So he said, a statement was made that she said out of court that he's got halitosis, sorry. I can say evidence, I can say trustworthy, I can say credibility, which is what you're going to be talking about today, but I can't say halitosis. So really everything the evidence professor was pointing out is hearsay. And everything, when you sit down and go, hey, guess what I heard? Hearsay. But he said the wrong thing. Hearsay. Everything is hearsay. So to come into court, it's strict. You have to have an exception. So what drives me crazy is there is an exception to the hearsay rule that debt collectors use. It drives me crazy because judges sort of like, well, let's just let it in. The word exception is something exceptional happened. The general rule is it's all hearsay. So for it to come in, it has to be exceptionally correct. So we're going to look at that. Again, warning, snooze alert. This is going to be boring. I hope it isn't. 3 things to ask yourself just if you want to knock out a debt collector document. Keep in mind, the main thing you're going to focus on today is how they get information in. So for example, the bill of sale in that video I talked to you about, it's going to have to be supported by an affidavit saying, yep, that's what happened. That's the hearsay that they're going to use to get the hearsay document in. Most account-stated claims are backed up either by a contract or an affidavit. It's an account-stated claim. So that's got to have an affidavit. So this is useful for you to knock out the affidavit. I hope it is. So look for the three things. Is the document an out-of-court statement offered to prove the matter asserted? An out-of-court statement offered to prove the truth of the matter asserted. And it's true if you can prove that the hearsay statement has an exception. So is there an exception that allows the document to come in to the general rule that it is hearsay, it can't come in? If something is hearsay, it cannot come in. Generally, everything is hearsay unless there's an exception. Was the document entered after litigation for settlement for self-serving purposes? So that's commonly done to me. I'll file these answers that I give to you with the counter affidavit, pointing out exactly how screwed up they are now. Nothing's going to come in. They'll suddenly pop an affidavit saying, yep, everything we said is true, and here's why, and I'm the guy. And so the first thing I do is I look at the date. If it is signed and sworn to after the litigation started, it doesn't have credibility because it was done in what's called for litigation purposes. It doesn't have credibility. So the two sub things you have to key on: is it credible? Is it trustworthy? And that's right in most rules, state rules and the federal rule. The federal rule is FRE 803, actually 801, but the 803 includes the exceptions to the hearsay rule, including also FRE 804. In your state, like I'm in Michigan, it's MRE 803, MRE 80, because it's Michigan rules of evidence. So whatever you're in Montana's probably MRE. You're in South Dakota, SDRE, I don't know. But they're all the same, basically. They all work off the same bicycle. It's just that the wheels may have a couple of different spokes, if you will. But they also work off the general rule, which is the federal rules of evidence. But remember, it's the reliability and credibility and trustworthiness that the court and the rules focus on. Here's some fun exceptions. I'm trying to make it fun. The present sense, let's put this up, Shazam. The present sense impression, a statement describing, explaining an event, a condition. And that means at the time it happened, someone said something without thinking, will this hurt Johnny? Will Susie have to go to jail? It was a present sense. It happened in the moment. I make the example, the car is on fire while witnessing a car engulfed in flames. That would be credible because you didn't have time to think about, how can I make this statement so that Johnny gets all the insurance funds even though he set the fire? So it's admitted as evidence because it so quickly occurs without a malice aforethought or any thinking about what you're saying. So an excited utterance, it's in a similar vein, a statement relating to a startling condition. I can't believe he just robbed the bank is what we say. Well, you wouldn't say there's all these people and you're like, I want to get Steve in trouble. Let me think about this. I can't believe Steve. Now that's not coming in because that didn't happen as the matter was occurring, okay? And then again, family records, a statement of fact about personal family history in Bibles, genealogy, charts, things that you're not thinking about getting people in trouble. And the evidence may be just supporting evidence or foundational evidence anyway. Reputation concerning personal family history among a person's family by blood, adoption, blah, blah, blah. There are exceptions to the hearsay rule based upon unavailability. I gotta tell you a quick funny story about that. So let's put this up. Rule 804. So remember, I think hearsay rule is 801. The exceptions are 803. But these other, and there's a really cool exception, 804, based upon availability. If the person that made the statement, the declarant, is unavailable to testify in court, we look to see if it has certain criteria to come in. So key points, as I say, about 804, a proponent of the statement must first establish the person isn't available. They died, they're ill, the memory loss, so they were of sound mind and body when they said it. Now they maybe have Alzheimer's, but there's some recorded, encapsulated statement that can come in if you show unavailability and whatever else makes it trustworthy. Here's some of the key exceptions under 804. If a witness previously testified at a hearing is now unavailable. You can just bring that testimony in, because when they made that testimony, they held up their hand. It's assumed they were telling the truth, and anybody that was against the evidence had the chance to kick in the butt or kill their evidence. But that can be used because it's already stopped. It's like taking a picture of something. You can't later go, that's not a picture. You can see the picture. So that's something that's already been sworn under oath to. This is my favorite, a dying declaration. There is an exception, dying declaration. Bob is dead. Bob is dying. He's laying on the ground. And Susie runs up to him, what happened? And he says, Robert shot me because I didn't pay him. Well, it's given credibility, by the way, if he dies. And he's unavailable, obviously, that's part of it, but where it's thought that we don't lie as we die. We don't lie as we die, so it's called a dying declaration. So obviously there have to be other reasons and reliable circumstances why this is coming on, but the rule says if they believe they're about to die and they utter, the guy Steve shot me, Steve's going down with that statement unless he can show otherwise. So it's given credibility because you don't lie as you die, supposedly. So I've had cases where the person was threatened with dying if they didn't lie, but that's another case. So wrongful procurement of unavailability. You can't just make the person unavailable if you want to use their testimony. And you must prove the declarant's unavailability as it goes to reliability. So let's look at the first bill of sale and assignment we got from that video I did. Let me put the video up again. Beating a Sallie debt collection lawsuit. Okay, thank you. Take a look at this nonsense. And you probably remember if you just saw the video. That's a bill of sale, Shazam, that's a bill of sale and assignment. So you would look, they would say, hey, this is coming in to prove we own the debt. It's usually attached to the lawsuit. But is it coming in? Look at the signature page, Shazam. So first thing you'll notice, not a date, no authorization for those parties to sign. Now, just for a second, before there's any signatures, if this document was true, the document lays on the ground, on a table. All these people that are now going to sign it, are they huddled there trying to squeeze their signature, or do they sign very different documents? And someone, if you look at the lines at the top, has just copied all these things into this section. So it looks like they're signing for SMB, private education loan grant, and all these others. Can you see what I'm talking about? It's just so unreliable. They even have copy lines in it. Use some whiteout if you're gonna lie, you know? So there's no dates. Nobody sat around squeezing in their signature. There's a signature for each page, and in each page for a signature. So look at the copy of that signature page. Look at the line. See how it appears put together. It would not be considered trustworthy and credible, and it's total hearsay. An out-of-court statement offered to prove the matter asserted, the truth of the matter asserted. 8036 is what's called the business records exception. I have to go like that when I'm talking, but same as it ever was. Same as it ever was. Anyway, so the 806 definition I will get to, but remember now, and this drives me crazy, as I said, crazy alert. I talk to judges, they go, well, Mr. Barker, that's coming in. I go, why? It's hearsay. Yeah, 8036. They don't even say why. And I go, well, Your Honor, that's an exception. The general rule is what he said and she said is going to be hearsay. There's actually a hearsay exception, by the way, hearsay upon hearsay, where hearsay is within hearsay, and I'm going to show you that. But they will say, nope, and this is what judges across the land are doing, so you've really got to know your stuff. 8036, the business record exception. And I'll put it up, Shazam, the key elements of Rule 8036. The record was made near the time by someone of knowledge. In the SLM case, there's no signature, no date on the signatures. The record was kept in the regular course of business, conducting activity, which terms include business, institution, blah, blah, blah. None of that is mentioned in that bill of sale. Making the record was the regular practice of activity. None of that. So that's out. So how do debt collectors get that stuff in? That's just total hearsay. They use, as they use in account stated statute claims, an affidavit. Let's put up an affidavit that actually I faced after litigation was already started. Shazam. I want you to take a look at that. That's and what they've done, and this is what debt collectors do. Look at the top. Business records affidavit. Is that what it's called? No. They're trying to alert the court. We're coming in under the business record exception. The judge may just look at that and go, okay, it comes in. So let's see if it comes in. Let's see if it has any, as they say, here's a law school, if it has an indicia of reliability. That's what my evidence professor say. Does it have an indicia of reliability? I'm sitting in my second day of law school going, how do you spell that? Boom, he's on to the next thing. So does it have an indicia of reliability? Is it reliable? Is it trustworthy? So this person says Dante Haley has signed something being duly sworn and states and deposes as follows. So those are terms of art, BS terms. But what's missing is there's nothing saying it's signed under perjury. So I imagine if it's an affidavit that is trying to beat the hearsay rule, it's going to be sworn to. Let's just take a look. It isn't. There's no notary on that thing. They're not even trying. They don't say in any way, shape, or form the most important thing about the business record exception. And that is state that you have personal knowledge and you helped maintain the records that are at issue. None of that is here. But the fact that they did not sign it under perjury, whoosh, off with their heads. It's out. And that is what's called hearsay upon hearsay. It's a out-of-court statement offered to prove the truth of the matter asserted, but there's hearsay within hearsay. They don't even try. There's so many things that I point out to a court about how bad the evidence is on the other side. Sometimes I run out of paper. And this is one of those I report to. Are you serious? So let's look at another account affidavit that debt collectors rely upon that you will see to get their bad evidence in. Shazam. That this time is called an affidavit of an account. Again, most account stated claims you're going to see or you're facing are supported either by a contract or generally an account stated claim is with an affidavit. That's why we do counter affidavits. Here, the person's not even trying. There's nothing about personal knowledge. You have to have that. And she doesn't even, yeah, you can like the story in this one. They don't refer themselves as themselves. They say he or she, and that's not a pronoun thing, if there's a woke environment issue here. That's them signing an affidavit that somebody else has prepared that did not know who was going to sign. So, but they don't say as they must. They have personal knowledge and took part in the maintaining of the records. None of that is here. In fact, they don't even say the thing that they're bringing. The reason they're bringing this is to support that the plaintiff owns the document. None of that is in there. It just says, plaintiff regularly purchases contracts from the original creditor. So this person saying under oath, the original creditor, as opposed to who actually gave it to him or their assignees. It's so wrong. There's no personal knowledge. There's no care. And so I go, I want to depose, it's Michaela Reeves in this case. Suddenly, she's gone. She retired or she's fired or whatever. Are they setting up an unavailability exception to bring this in? Stay tuned. If you want to see more on this actual affidavit and how much fun it was, go to my Smelly Socks video. Just look for Smelly Socks, S-O-C-S. I'll put it up for you. Shazam. There it is. Oh, Smelly Socks. There you go. Boom. I'm actually litigating that case, and it's going to fun places. So I actually laughed when I saw that affidavit. So let's look. So after you look at the Smelly Socks video, again, the business records exception to hearsay is the most overused, abused form of getting stuff in, and sometimes judges are lazy. They don't want to break this down. you want to, because you have to show a lack of credibility and a lack of trustworthiness, especially if the affidavit is signed after you started litigation. The courts generally don't let that in, and they treat it as real full-blown hearsay unless it's really credible. But affidavits signed after the litigation, when you've got a chance to see how Parker's defending against you, suddenly you have all your I's dotted and your T's crossed in an affidavit. Let's look at that. And so they're very strict. If it's signed after litigation, it's rarely coming in. But again, judges kind of look the other way. They just want to move the case on. So the things you look for in your documents against you: always look at a claim of personal knowledge. If it's missing, it's out. It's out and z. It's gone. Off with our heads. Look for credibility. Why was it signed? When was it signed? Was it dated? Oh, another thing, by the way, you're going to think this is not possible, but I've seen it. Go check out the signature of the person signing the affidavit. Go check out if there's a notary. Go check. You'll be so surprised. Sometimes you'll catch him. The person doesn't work where they say they work. That's another thing. Like in that last one I showed you, she couldn't even say what she did or with whom. She just said, I'm an agent. Well, I'm an agent of my client, but I'm not him. I am as far as courts go. But she has to say, when you're overcoming a hearsay deal, when you show an exception, I work in this department. I work for the Shields Company, and it's our job to put together all these documents. And I have personal knowledge. On this date, I did. If none of that is there, it's gone. So is the document trustworthy or one-sided or brought during litigation? It's usually brought as self-serving purposes. In that instance, I'm going to put this up there, and this is my opinion, okay? Because I'm doing this for 30 years. Look at me. Put up the business records affidavit again, please, Shazam. Why would they place this document in a court situation to prove they own the debt, which, by the way, they really kind of cooked their own goose. I actually got to turn this around on them. But why would they bring this and the way they did it? If you notice, it wasn't dated. That's like nothing happens. You can sign, but if you don't date something, everything you sign, today if you sign something, tomorrow you'll notice place for signature, place for date. It's as important as the signature. It's a affidavit. Why is there no notary and why is there no signing date? Here's my opinion. Because they don't want this looked upon as something signed after litigation. See? If it's signed after litigation, it's obviously not credible. Why is it not sworn to? Well, in this case, it was clear that they don't own the debt. So they're putting together something to try to make sure they do with the pretzel stuff they have handed. And so they don't swear under oath, so it's really not lying, right? In case you're that naive to think, oh no, I've seen it. I've seen it. So people do what people do, and it's about money. When it's about money, and they're mad as hell, by the way, that you're fighting them, because you owe that debt. Even though they don't have the proof, you owe it to them. I've seen stuff. So maybe think about why that thing wasn't dated or sworn under oath. That happens. So boring subject, let me give you something to laugh at. Remember, the exception is not the general rule. Be wary of judges that make the exception the general rule. There's another expression in law school that said, don't let the exception eat the general rule. And that's what's happening. This business record exception is regularly allowing by judges. Yeah, come on in, bring it all in, but it's hearsay. And they're allowing the exception to eat the general rule, which says everything is hearsay. So here's a funny joke to end. I got this off the internet, and there's credit to whoever I got it from. Shazam. Ladies and gentlemen of the jury, we have hearsay evidence from the lady who told a friend of the hairdresser's cousin Julie. What more do we need? I'm trying to make the point. It's a hearsay statement, an out-of-court statement offered to prove the truth of the matter asserted. The general rule is everything is hearsay. If there's an exception, You've got to carefully go through it. Look for 8036 business. If you ever looked at an affidavit and you go, why are they saying in the regular course of business, or I have personal knowledge? Because they're trying to put the rule in an affidavit, then filling in the blanks. And those two examples are common examples that never meet the rule, and your judges go, well, she does owe the debt. Not an issue. You're on a, I may owe the debt, I don't owe it to the debt collector. I'm just throwing it in there. So good luck. I hope I kept you awake. I probably didn't. But go get them. Check out Hearsay and keep saying to yourself, an out-of-court statement offered to prove the truth of the matter asserted. He said that she said that he's got halitosis. Hopefully I didn't give you bad breath from this video and you stayed awake. Like, love, and subscribe, and leave your comments if you're still awake. Thank you very much. Have a good day. Bye.